Showing on this episode of Law Weekly, reactions to the judgment on Executive Order Number 10, the travails of Super Cop Abubakar, and justice sector reforms. We have the views of a senior advocate of Nigeria, Okoli. Also showing on the program, issues with the use of technology for the practice and business of law. We also have a recap of the top legal stories in the news. Hello and welcome to the program. I'm Shola Sheyeli. Reactions continue to trail the Supreme Court judgment on Executive Order Number 10, with many lawyers insisting that the court did the right thing. I spoke to Senior Advocate of Nigeria, Okoli, to get his views on these and other issues.
First and foremost, I would say, even without reading the judgment, that I am not surprised in the sense that the executive order left, right, and center by the federal government, especially under Buhari's presidency, it's a relatively new phenomenon, as if the presidency of Nigeria started in 2015. I'm old enough to remember a bit of Shayari presidency. There wasn't much anybody talking about executive order. Even Obasanjo, who temperamentally was a lot more inclined to testing the very limits of presidential powers. But even at that, we did not see recourse to executive orders, which is a way where the presidency could overreach itself. Now, all of a sudden, we discovered lots of usage of executive orders, and more often than not, controversially, stretching the boundaries of the constitutional definition or delimitation of the powers of the presidency and even the powers of the federation vis-a-vis the states. So where in the presidential order that the president will begin to dictate, as it were, to the states in a federation, it's, from point of view of principle, it raises some curiosity. So for me, I'm not surprised. The way that the way the judgment went, speaking about general principles, yes.
Okay, let me move on to the case of Abubakar, the Super Cop, which is also very topical right now. Some lawyers are arguing that he can be extradited. Some others are saying that he cannot. I have heard some lawyers cite Section 3, subsection 11, number 9 of the Nigerian extradition law, which says that extradition application will be rejected where the fugitive criminal has been charged with another offense under Nigerian law, other than the offense for which his surrender is sought abroad. I've heard some people cite this, and the interpretation has been, depending on who you're listening to, interpreted in different ways. Some people think that the move to charge him under Nigerian law with some offenses is just to prevent his extradition because of this section. But I don't know how you're reading this and what the extradition law says.
For me, I am not so much going to be as critical as it is. I'm not going to be too, for us to be detained too much about the fine points of law. For me, the Extradition Act is, I've read it, it's written in plain English. The literal interpretation on the surface that with his present problem, I wouldn't say definitively because I'm not a judge. It's only a court of law that can speak those pronouncements. But reading it and interpreting it literally, as the court says that we should subject the statute to literal interpretation, it doesn't seem that you could just whisk him off to US when there's a major charge here. Because, let's face it, criminal offenses are wrongs against the state. So, which the state has a right to redress. If he's offended us significantly, and there's also some offense to the US, charity begins at home. It is in the interest, self-interest, jurisprudentially speaking, of the Nigerian state to make sure that offenses against its law, an attack against the foundation of the state, is properly redressed. So to that extent, you can understand the jurisprudential basis where that particular piece of provision of the Extradition Act is, that if you have committed an offense here, the state that has custody of you, of the offending person, has, as it were, right of first refusal. It is jurisprudentially prior, it's right, priority. So that. But for me, I move away from those strict legalese and look at the wider issues that it is well and truly shocking that a man who everybody had looked upon as a, not just super cop, it's like an inspector general of Nigeria in waiting. We haven't, let's be clear, he hasn't had his day in court, but so much is already in the public domain that we will be justified in discussing some of those things. Because for me, my point is, like they say, Caesar's wife should be beyond suspicion. You live above board. There are certain things that he shouldn't even allow himself, given his lofty position, for there to be a whiff of suspicion. As a lawyer, there are certain things, it is not criminal, but for me, there are certain things that will say that it is not compatible with my status as a lawyer, much less as a senior advocate of Nigeria. The same way you're talking about people in the priesthood. The same way for public servants, particularly policemen. So what you have in the public domain, even without making a definitive statement, is a source of worry that this is a calamitous collapse of the system. Because what they are talking about, what is already in the public domain, first, his dealings with hush puppy. And I will tell you something, it's not colonial mentality. By the time the law enforcement agencies in whether US or UK starts looking for you, they have it loaded. It's not like what we do here with our people. They will charge somebody to court.
And start looking for the evidence.
Then they go there and it's so ridiculous. They oppose bail and say that why they want to oppose bail is that the person would interfere with investigation. So you haven't finished your investigation, then you quickly rush to court. In US, I've had the privilege of being close to criminal prosecutions in the United States of defending people. They drop the file to you. You do plea bargain in the Ibori case, which is where I'm coming with some of this very cynical attitude of Nigerians. Virtually the same set of facts that Ibori went scot-free in Nigeria, but he got to UK. He changed his plea. And you see, that's what we keep talking about in Nigeria with the law being so unstable. You get one judgment here, you get the other place. In UK and how it should be in Nigeria, a diligent lawyer could tell you with certain level of certainty the prediction of what's going to happen. And that's what happened there. For example, I go to US, I have to advise cases that in Nigeria advise the US lawyers or the clients who have things here or UK. You always are being very defensive because these people have the same legal training as with the common law. They bring up a judgment that they know the facts and they say, how do you justify it? You're talking from two sides of the mouth. So any Nigerian lawyer who's had some sustained interface with lawyers in Britain and UK will will tell you. Because they keep throwing things at you, they will tell you, how do you justify this judgment? And, you know, you are...
You're at a loss for words.
Precisely.
You don't know what to say.
Again, so it is of utmost importance that all of us, because what it now happens, you know, a lot of times you go on the social media, the young lads are complaining, oh, no payment, no payment. The truth of the matter is that where you have what I call rule of law deficiency, the practical implication is that the practitioners of law are the first casualty. People would not want to subject their dispute to resolution within such a capricious, broken system that is a Russian roulette that you're doing. So you advise a client, you have a fairly good case or whatever, and then the what now comes out is totally, it's a grotesque distortion of what you would have. So a lot of times, instead of saying this is what is going to happen, you're still saying, well, a lot depends on the judge.
There's no certainty.
There's no certainty, and that is the fundamental issue with rule of law.
So, Leonard Silk, what must give? If we're to talk about solutions, reforms, and because you've identified so many problems, and a lot of the lawyers also know these problems, the delay, appointment of judges, you put people who are not fit for purpose in office and say they will learn on the job. You know, some of these issues that you've brought out. If we're to talk about reforms, and I know that the NBA is at the forefront of driving reforms, there was a justice summit that was held in Abuja a few weeks ago, and we had members of the bench, members of the bar, all saying that enough is enough and we need to push for reforms.
You see, we lack good men in positions. You know, we just take one phrase and run away with it. Oh, build the institutions, not men. Build the institutions, not men. What makes the institution? It's not just the men. With all the over 200, 300 years institutions Americans thought they had built, it took a Donald Trump to virtually crash it down. If it's my thesis, and most informed people believe so, if Donald Trump had won a second term in the United States, by the time he finishes, all those institutions they keep talking about, it will crash that. Even the Republican Party, that is an institution in itself. So we need to get good men in politics and in positions where they will need to stand up. Because the issue of administration of justice is too important to be left to only judges or even lawyers. Because at the end of the day, this interferes with everyday lifestyle. We're asking why Nigeria has become what it is. The youths are getting involved in all sort of ritual. It's because there's an anomaly. Like my good friend and brother, Professor Kanu, will say, you can't run any system on the basis of Ejoma Binu. Somebody has committed mayhem. He goes to kneel before someone, they go and start begging. No, the rules are there. You break it, then we follow the rule. So you have rules how you go to appoint people. For starters, what we want is a situation where the Supreme Court, like in the United States, controls its docket. Or what I propose is that each geopolitical zone will get its best. 6. Then the other 3, by whatever criteria we use to define merit, will get it. And within that 3, we will cater, in addition to merit, that we will take cognizance of some significant section of the society that may not have been represented in that 6. 1, if there is no lady, which is quite possible, after that 6. So when we're taking these 3 to make up, we keep that in mind. If for any reason there is no Muslim in this number, and given the importance of Sharia law, then we also take into consideration that among this marriage will be somebody who's well schooled in Islamic Sharia jurisprudence and other things. This will put it there. So, and we'll make sure when you have 9, you wouldn't have a tie. And then we would, because if things are not spelled out in Nigeria, we have a way of making straightforward things complicated. If for any reason a judge is incapacitated, that would mean that you're left with 8. Automatically, any case coming up there, my proposal is that the president of the Court of Appeal automatically will sit with those people because it's basically the same qualification they have. If there are 2 missing, the next ranking judge will sit with them on an ad hoc basis. Of the Court of Appeal will join the president so that we make sure that each particular point in time, we won't say we are lacking quorum. They can sit there and go back. But we need to free the Supreme Court and make it really well and truly supreme. And for me, if United States, with all its complexities and everything, is making do with 9 justices, I can't see why we cannot prune our own number to 9.
Welcome back. The president of the Nigerian Bar Association, Olumide Akpata, says he's committed to the digitization of the legal profession. He spoke alongside other legal practitioners at the Business of Law Conference, which held in Lagos. Here are some of the highlights from that event. In compliance with COVID-19 protocols, the strictly law business community limited physical attendance to this event and encouraged more people to join online. This is also in keeping with the theme, the use of technology for the practice and business of law. The convener notes that technology is a major enabler of businesses. She encourages all lawyers, and particularly young lawyers, to desist from running down the profession and instead identify opportunities to grow their practice and make the legal sector better.
I think that rather than complaining about what is not working for us as young lawyers, we should begin to think about how we can make things work. What we need to do to make this industry better. What we need to do to make this industry, to keep raising the bar of this industry. And that's the power of technology which we're talking about today. You can set up your law practice. You can do a whole lot of fantastic things rather than complaining.
The president of the bar, who delivered the keynote speech, set the tone for the conversation ahead with these opening remarks.
One of the problems I find in our profession is that lawyers are still talking about technology as if it's an option. Even to get our lawyers to pay bar practicing fee online is a debate. And what I have said is that whether we like it or not, I am going to drag this profession kicking and screaming into the technology, into the digital space. We are going to be launching the Digital MBA April or May. We're working on it. We're moving the MBA. There's no other option.
The Attorney General of Lagos, on his part, gave the assurance that the government is committed to deploying technology for the practice and business of law. He calls for more collaborative efforts.
There's been a systemic rot from way back. And fixing this rot, sometimes it appears as if they're just running on the same spot. So there are problems plaguing almost every facet of the administration of justice, from the public sector, from the judiciary, even in private practice. We need to, quickly devise ways and means of overcoming all these challenges. But one sector cannot do it on its own.
The conference broke into panel sessions. The first panel dwelt on digital transformation for the justice system. The Chief Judge of Ogun State and the Solicitor General of Lagos shared perspectives on how their states are leveraging on technology.
Some of us still do virtual sitting. I do virtual sitting for motions, judgments, rulings. I sit virtually for all this. I have 1 or 2 judges who take most of their cases virtually. And just last year, I thought, what can I do without finance, to go into this e-filing, e-registry, and e-payment. E-payment is very important so that you save a lot of money. You know there's always Nigerian factor in everything. There's always the loophole that is difficult for you to block. But with e-payment, we know that we'll gain a lot. And I called the law pavilion people, and they were willing to be in partnership with us. And very soon, we'll be launching our e-filing, e-registry, and e-payment platforms.
Now, the next level we have gone in Lagos State is to have a plan to digitalize the court system. And we have already started by deploying this technology to 10 courts in the state. And what this is going to do is to transform the way the court proceedings is done in Lagos State. Now it's going to be equipped with screens, court recording system, the ability to transcribe from audio oral to words, and this will expedite the process of getting court records. Normally, it could take up to a month or two. Now, when we deploy this digitalization system, it's going to now take only about 2 to 4 days.
For the senior advocates on the panel, there are some core parameters for measuring global judicial performance, parameters which the Nigerian judiciary have sadly not met.
Judicial services are a public service delivered to the public as a pillar of government at the cost of the public, and it must be accountable. There must be measures to account. House status, and in Kenya and in Ghana, they do surveys. Forget about South Africa, because this would be regarded as advanced jurisdiction. So the fact is that there are measures. You can order a lot of equipment at great cost. And I know many of those judges across Nigeria who are involved, I don't want to mention names, who are directly involved in the NGC implementation of digitization. They will tell you privately that much of the deployment is ineffective, it is unnecessarily delayed, and that very often, as in all things Nigerian, corruption is at the root of sabotaging that process.
The magic circle firms in the UK came together, so that also can happen. That's what the MBA. Law firms can come together to see ways in which we can assist the work of the judiciary, especially in the use of technology in the justice delivery sector. And there are quite a number of other ways that we can actually think of from time to time beyond keeping the blame on judiciary to see that we get to where we really want it to be.
The panelists also agreed that adequate funding of the courts and financial autonomy of the judiciary will hasten the digitization process. On the home stretch, let's now bring you a quick recap of some of the top legal stories in the news.
We begin with the report that a 3-member panel of the Court of Appeal Abuja Division has set aside the judgment of the FCT High Court filed over the 2021 ward and local government congresses for lack of jurisdiction. The court quashed the lower court's judgment, which gave Senator Ibrahim Shekarau's G7 faction of the APC in Kanu victory over the faction led by the state governor Abdullahi Umar Ganduje. Upholding the appeal filed by the Ganduje-led faction of the Kanu All Progressives Congress, the appellate court held that the High Court lacked the jurisdiction to try the case. Still in Abuja, but this time the Federal High Court, Justice Binta Nyako has fixed April the 8th to rule on the preliminary objection filed by the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, challenging the validity of the 15-count amended charge preferred against him by the federal government. The trial judge fixed the date after Kanu's counsel, Senior Advocate of Nigeria Michael Zekeme, and the prosecution, Mr. Shuaibul Labaran, adopted arguments for and against the defendant's preliminary objection. Meanwhile, Mr. Zekeme has raised an alarm that his client's eyesight has deteriorated and he may go blind if nothing urgently is done. In Lagos, a police inspector, Ibrahim Isiaka, has told the State High Court sitting in the Tafawa Balewa Square area how the body of late Usifo Ataga was discovered. He was testifying as the 6th prosecution witness in the continued trial of a 300-level mass communication student of the University of Lagos, Ms. Chidinma Ojukwu, who is suspected to have killed Ataga, the chief executive officer of Super TV. The witness, who is the investigating police officer in the case, told Justice Yetunde Adesonya that the body was found when the owner of the apartment, Mrs. Nkechi, came to report the incident to the division on June the 16th, 2021 at 11:30 p.m. And we round off with the case of 5-year-old Hanifa Abubakar, who was allegedly killed by a school proprietor, Abdulmalik Tanko. The case assumed a new twist at the court hearing on February the 14th when the principal suspect, Abdulmalik Tanko, who had earlier confessed to the kidnap and killing of his school pupil and of demanding a ransom of 2 million naira, suddenly denied the charge. He, however, agreed to only one count of conspiracy to commit kidnap. The Kanu State Attorney, Abdullahi Lawan, has given the assurance that the state government will provide witnesses so the case can make progress and to ensure justice is served. The court has adjourned to 2nd and 3rd of March for the next sitting.
That's the show. Thank you for watching. Please catch up with past episodes on our YouTube page. I am Shola Shoyele. See you next week.